morning, President John Dramani Mahama, he has begun consultations with the Council of State, and it follows the submission of 3 petitions seeking the removal of the Chief Justice, Gertrude Saki Tokonu. We got to know all of this from a statement that came from the Minister for Government Communications, Felix Kwakye-Ofosu. It's a very short and straightforward statement. And that statement was signed by Felix Kwakye-Ofosu. He's the Member of Parliament. He's also the spokesperson to the President and Minister for Government Communications. Success Donwulo will help us get into the details of this statement and what it means. I'll read to you what the statement signed by Felix Kwakye-Ofosu contains. It says that President Mahama has received 3 petitions from various persons seeking the removal of the Chief Justice. The President has forwarded the 3 petitions to the Council of State to commence the consultation process mandated by Article 146 of the 1992 Constitution. So this is what Felix Kwakye-Ofosu has told us, and now we know that the consultations have begun with the Council of State and follows the submission of the petition seeking the removal of the Chief Justice, Gertrude Saki Tokonu. Let me talk to you about Article 146 of the Constitution of the Republic of Ghana, because that is what the petition to remove the Chief Justice is based on. For the removal of the Chief Justice, this is what happens. The President will receive the petition. In this case, we know that 3 petitions from 3 different people have been received. Now, the President consults with the Council of State to determine whether there is a prima facie case. Sixers will help us understand what this means in law language when they talk about a prima facie case, what it means and what effect it has on all of these cases, or what we're talking about right now going forward. The third on the to-do list, if you like, is that if there is no prima facie case, then the petition is dismissed. So, in brief, we're looking at these 3 things. Let's look at the other ones. Now, if there is a prima facie case, a committee comprising 2 Supreme Court justices and 3 other persons who are not members of the Council of State nor lawyers, they will be tasked to probe the matter. After they probe the matter, their recommendations are given to the President, and the President is bound by the recommendations from this committee that comprises 2 Supreme Court justices and 3 other persons who are not members of the Council of State, nor MPs, nor lawyers, who are tasked to probe the matter. Sixers is joining us to talk to us about what a prima facie case is. Sixers, what is a prima facie case?
Simple, plain language. On the face of evidence that has been gathered so far, the allegations raised or leveled against you have some merit to them. And so you have, that's why you hear some people say you have a case to answer. So we say that Crosby is being charged with, Crosby is been accused of, I almost said, okay, let me think good for you.
Sisters, why don't you just move to there? Yes, but make your point while you talk about it.
I know it. So Crosby has been accused of embezzlement. Now there's an investigation that is done. Some pieces of evidence gathered. You are presented before a committee.
Right.
And the committee says that, or even a court. Then the court says that, well, on the face of the evidence that we have right now, as we speak, there is some amount of truth to the allegations that have been leveled against you.
Right.
So they say you withdrew money from this account which you were not supposed to withdraw, and applied it to 1, 2, 3 businesses or interests which you were not supposed to apply to. Then yes, on the face of it, there's actual evidence that you withdrew the money. There's actual evidence that you did not use the money for its intended purpose.
Yeah.
So you have a question to answer. What did you use the money for?
Okay.
Then it means that evidence suggests that there's some merit to the allegations that have been leveled against you.
I see.
So in the interim, preliminarily, there's some merit to it. Come and respond to it.
Okay.
So if applying it to the context that we have here, if it is established, for instance, that the Chief Justice is may have done the things that she's accused of doing, then
in the 3 petitions,
then the matter would then be referred. That is why we don't, because
it will be referred to.
I'm sorry.
What I'm asking for, the matter will be referred to who?
To the committee.
Right.
Because we don't want to waste time.
Okay, so at the moment, it is the Council of State that is determining what? Let's go through how it goes, how it happens again. So the President receives the petition. The President consults with the Council of State to determine whether there is a prima facie case, and then if there is no prima facie case, the petition is dismissed. Let's move on to the next one now.
Okay.
If there is a prima facie case, then a committee comprising 2 Supreme Court justices and 3 other persons who are not members of the Council of State, nor MPs, nor lawyers, they will be tasked to probe the matter. So at the moment, the President is consulting with the Council of State to determine whether there is a prima facie case against the Chief Justice.
So the excerpts you are reading are from Article 146 of the Constitution.
Yeah.
And Article 146 provides for 2 different processes. One for the removal of justices of superior courts. And when you say superior courts, you are talking about the High Court.
Yeah.
You are talking about the Court of Appeal. And you are talking about the Supreme Court. Those are the superior courts. And the second process that falls under Article 146 is about the removal of the Chief Justice. So the Constitution uses the language, a justice other than the Chief Justice. Okay. So if we go to the very top of that's clause 1 of Article 146, it talks about a justice of the superior court or a chairman of the regional tribunal. Remember, we keep talking about guaranteed, secured tenure of office. That once you get into this particular office, you cannot arbitrarily be dismissed from the office. That is to say that you cannot, the appointing authority cannot wake up one morning and say that I don't like your face, go away.
Okay.
There has to be a process.
And this is the process.
And this is the process.
Now, we don't know the details of the petition. It remains undisclosed. All of this will happen behind closed doors. But we know that this development, so far as the process has begun, it signals a beginning of a formal process that could lead to significant changes within Ghana's judicial system. Let's walk you through the removal of justices of Superior Court and chairmen of the regional tribunals, like sisters you were talking about. What is the first step?
Okay, so let me start from clause 1 of Article 146. A justice of the Superior Court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior.
That's 1.
Or incompetence.
2, maybe.
Or on ground of inability to perform the functions of his office.
Okay.
Arising from infirmity of body or mind. So there are 3 conditions here. And the third condition has 2 sub-conditions.
Right.
First one is stated misbehavior.
That's 1.
Questions have been asked about what constitutes stated misbehavior. What is misbehavior? Is it when the Chief Justice or the Justice, we are talking about justices generally.
Yeah.
Is it when the Justice decides to go to the popular wache joint in the neighborhood to go and sit there, order wache and sit there and eat? Is that misbehavior? Is that when the Justice, a case is brought before the Justice and the Justice decides that I lean towards CPP And so this particular person who is a known CPP activist will gain my favor. Is that misbehavior? So questions have been asked about that.
What misbehavior in
The
this
second one
is
incompetence. Again, incompetence questions have been asked. What is incompetence? What constitutes incompetence? Is it when you are unable to apply the rules of the law to a particular case that is before you? Is it when all your judgments, rulings, and decisions have been appealed against and won? For instance, if you are a justice of the High Court, anytime there's a case before you, you make a determination of that matter, it goes to the higher court and they overturn it. Is that incompetence? Does incompetence mean that you simply do not know your job as a judge? Is that incompetence? Now, the third ground that we are looking for is inability to perform your functions, the functions of your office.
Yeah.
What does that mean?
In this case, the functions of a chief justice.
Or a justice.
Right.
This applies to both of them.
Yeah, I get it.
Okay. So either chief justice or justice of the superior court. Remember, the chief justice is also a justice of the superior court. We say that the chief justice is a member of all the courts.
Yeah.
So the chief justice can sit in any court in the country. Now, they say arising from infirmity of body or mind. Is it when you have an accident and you have a fractured leg, you can't go to court again, and so you can't, hear cases? Is that inability to perform the functions of your office?
Yeah.
Or insanity, does that constitute inability to perform the functions of your office? These are determinations that would be made. Okay.
And so far, we don't know of anything in relation to the third condition that you've spoken about. And I'm talking about...
in relation to the three petitions that we hear about.
Yes, from our engagement or our sight of the Chief Justice, the third ground or the third condition you've just spoken about seems to be the least to be applied in this instance.
Seems to be. I like that phrasing.
Yes.
Seems to be.
It was carefully selected.
Yes. It would appear that it is not the ground.
It is not included.
One of the grounds. But we cannot tell.
Yes. So it means that it appears that the grounds may be stated misbehavior or incompetence.
It would appear so.
Okay.
So if you go to clause 3, and we'll pay attention to clauses 3 and 6.
Okay.
In trying to draw the distinction between a removal of an ordinary justice of the superior court and a removal of a chief justice. Okay. So clause 3 talks about the removal of a justice other than the chief justice. And it says that the petition shall be referred to the chief justice, who shall determine whether there's a prima facie case to be answered. So in the case of a justice other than the chief justice, a petition, Crosby petitions Mr. President. Mr. President
will give it to the chief justice.
Okay. The chief justice determines whether this is worth any attention at all. Should we spend resources going through the process to remove this particular? So if you recall, in the Anas expose, the petitions that were presented following the expose for the removal of the justices, all those petitions went to the chief justice at the time. Now we will jump straight to clause 6, which talks about the removal of the chief justice.
In fact, 6 is before you get to clause 6, it reminds me of the removal of the former EC chair, Charlotte Osei. You know that that petition also went to the then chief justice.
Yes.
So it falls in line with that. What we're talking about, right?
Yes. Okay. And so the chief justice, that's clause 6.
Yes.
If the petition is for the removal of the chief justice, then the president will consult the Council of State, appoint a committee.
Right. So
that consultation.
The first one is to consult the Council of State and then appoint the committee.
So I'm the chief justice.
Yeah.
Abiam is aggrieved. Maybe Abiam has an issue with me as chief justice. Abiam, you are president. Abiam petitions you, says that look, this guy, the way he wears his suspenders, he cannot be our Chief Justice.
Yeah.
So, Mr. President, remove the man. You, Mr. President, you will call Kunzo, you call Wamameya, you call Etonam, you call Helen. That is your Council of State. Into a meeting and you tell them that there's a petition for my removal. What do we do? First thing, the three of them sitting with you will appoint a committee. You will constitute a committee, and this is the composition of that committee. You have 2 justices of the Supreme Court. So you determine that Justice A of the Supreme Court, Justice B of the Supreme Court come together. And you appoint 3 other people who are not members of the Council of State.
Yeah.
Those 3 other people will not come from that Council of State.
Okay.
They will be what you call ordinary Ghanaians.
Me and you.
We the people.
But we are more ordinary than some people.
So you will appoint some of we the people.
Yeah.
To join the 2 justices of the Supreme Court to make a committee of 5.
Yeah.
And these 3 other people, they shouldn't also be members of Parliament.
Right.
Okay, so that's why it simply put, we the people.
You can come and pick Abiam.
And they shouldn't be lawyers too.
Okay, Abiam and Frederick Kunzo.
So the 3 people who will be appointed, they shouldn't be lawyers. They shouldn't be members of Parliament. They shouldn't be members of the Council of State.
They should be who?
We the people.
Can they be ministers? The Constitution did not say.
It didn't specify.
Can they be presidential staffers?
It didn't specify.
Okay.
But in the ordinary understanding of this, if the people are not allowed to be members of Parliament, they are not allowed to be MPs.
Yeah, well,
it means
lawyers.
that the framers of the Constitution simply wanted a free, fair process from people who are non-aligned. People who can think straight without any coloration.
That is your interpretation.
Is how I am seeing it.
That is how you understand. But that's what the Constitution has said. Because the Constitution did not say. It said the people you should not appoint. It didn't say the people you should appoint. So maybe...
Well, that's another argument. Somebody could argue that, well, if the Constitution did not want us to appoint presidential staffers onto that committee, the Constitution would have specified, as it has specified directly against appointing members of Parliament.
So with this space, with this, if you like, lacuna, the president can appoint the vice president, because the Constitution did not say the president cannot appoint the vice president.
So can you say the president can appoint himself?
Because the Constitution did not say.
Exactly.
Okay.
So I'm saying that there's an argument to be made there.
I get it.
There's an argument to be made there. But there's also the reasonableness of it.
Of course.
That you cannot say that, members of common sense. You cannot say that members of Parliament are disqualified from participating in this committee. But a presidential staffer, a known, say for instance, you go and appoint Shamima Muslim, who is a deputy spokesperson to the president, because the Constitution did not say don't appoint your spokesperson.
If you do that, it defeats a certain purpose. It defeats
the purpose.
Okay. Let's go to clause 7.
7 says that committee which shall be appointed will then inquire into the petition.
Okay.
And that inquiry is looking for the merits of the petition. It's not going to now consider trivialities and say that, the colors of the suspenders sometimes are no good, and when he sits in court, he is more interested in adjusting his suspenders than listening to the people, or when he sits in court.
They're looking for the substance.
The substance.
Okay, the allegations level.
Does the man know his law?
Okay.
Does the man apply the law to the facts? Are there cases that you can say have demonstrated
so the
his incompetence?
Come, explain to us why you say A, B, C, D. But in this case, too, there's a fair hearing process, because the CJ or the accused person in this case is also allowed to come and defend him or herself
in fact, come and make your case.
Yes, come and
make your case. You are the one making your case. So when the committee is constituted, you then appear before the committee and you make your case. And you say that, look, this Chief Justice, under the tenure of the Chief Justice, we have not seen, say, growth of the courts, for instance, or justice delivery, for instance. And where will you place that? Incompetence?
Can this committee look beyond the petition?
No.
It has to be with a petition.
Yes.
Okay.
I mean, even in court, when you go to court, the court doesn't go beyond what you bring.
Okay.
What you want the court to do for you is what you bring to the court.
So after the committee looks into this, they are looking to establish a prima facie case as they inquire into the petition.
No. The committee. No, the committee is looking into the matter.
Right, into the prima facie case has been established already.
And making a recommendation to the president. The choice of the word. It says recommend to the president. So the committee would say, upon consideration of the petition, merits of the petition, the evidence adduced before the committee on this petition, we think that indeed the Chief Justice is unable to discharge the duties of his office or her office because he's suffering from the infirmity of the mind or of the body.
The conditions stated in Article 146.
Exactly.
Okay. So,
and the other important feature, because we journalists, we like conconsa, we like filler. Before you realize, they'll start saying, "Oh, we want to hear the petition. Let us telecast the petition. The hearings of this, the process are to be held in camera."
Okay. And the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or any other expert of his choice. The recommendation by this committee, this 5-member committee that the president will set up, in consultation with the Council of State. Their recommendation is binding on the president, I understand.
Yes. So if they say remove the man, well, the Constitution uses the word shall. It says that the president shall act in accordance with the recommendations so provided. But you know that we have also found reason to interpret the word shall to mean otherwise in some instances.
I see.
But if the Charlotte Osei proceedings are anything to go by, we know that the word shall
is shall.
Is shall.
Shall is not maybe. There's also an interesting bit to all of this, and this is in the clause 10, talking about when the petition has been referred to the committee under the article, the president has something he could decide to do. That is discretionary on the president. Talk to us about it.
Okay. So that is found under clause 10 of 146.
Yes.
And it says that the president, acting on the advice of the Council of State, will suspend. Suspend the Chief Justice. Now, if there's a process going on against you, we hear the word interdict. You know, in
police terms.
In police terms.
Yeah.
In public against public servants and civil servants, when there's an action against them, you hear that the person has been interdicted.
Yeah.
The whole idea is just so that you don't remain at post
and interfere,
sabotage, try to tilt the process.
Comme ça.
As you people often say.
1, 2.
So that it says that you go, stay at home. Let us go through this process. Let the process be fairly followed through with. If by the end of it, we realize that there's actually nothing against you, we bring you back. But if at the end of the day we realize that, the committee says, fire the man, fire the woman, then
you're not here already, so you stay there.
So just continue staying where you are.
Stay at where you are.
But you see, all of these processes are done in the spirit that there'll be fairness, there'll be transparency, there'll be justice done by the accused. So that it's not like, because
I want to remove him and we have brought petition here, he's packing
just go.
But you know that no Chief Justice in Ghana has been removed before. Successfully removed through the process outlined in Article 146.
Are you asking me or are you telling me?
Now, I'm telling you, the most notable case involved in the Chief Justice removal would be that of Georgina Wood. So she faced a petition for a removal in 2010, but that process did not lead to a removal. In fact, Justice Kpega, he petitioned both President Mills and then Mr. Mahama during his first term for the removal of a ladyship Wood. In a third petition to Nana Akufo-Addo, well, that petition, obviously, she was not removed, so that petition did not stand. In a third petition to Nana Akufo-Addo, driver Ernest Obri-Latte of Suhum petitioned for her removal as well. None of this petition led to the successful removal of ladyship Justice Georgina Wood. So while the removal of judges under Article 146 have occurred, a successful removal of a Chief Justice is unprecedented in Ghana's legal history. That's true. It has not happened before.
Just like we have never had a sitting electoral commissioner removed.
Exactly. Until it happened to Charlotte Hossein. There are some challenges to, if you like, a successful removal of somebody like this. There's the bit about political influence. Since the president plays a crucial role, there are those who think that the process could be influenced by political considerations. Then comes...
That is why we see an elaborate process.
But it is
unfortunately
with the
for us,
of the president.
It's all what?
The president has a role to play in almost all of the process.
The president actually has no role.
The president is appointing the three people.
The president is just a medium through which the process starts and ends.
Sisters.
If we go strictly, relax for me. If we go strictly by the dictates of the Constitution, the Constitution says that if somebody doesn't like the hairstyle of the CJ, and once the CJ removed from office, the person has to send a petition to the president.
Yeah.
Let me take you back to the that was clause clause 6. Let me take you back there. Let me read it exactly what it says.
Okay.
Where the petition is for the removal of the Chief Justice, the president shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the president, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. The president has been mentioned like 3 times in this particular clause. Relax. Like 3 times. And the president's role in all of these mentions is to act in a particularly dictated manner. It says that the first thing you shall do, Mr. President, is to consult the Council of State in appointing a committee. The Constitution did not say sit in your office and appoint a committee. It says go to the Council of State, sit with the Council of State and appoint the committee. Number 1. Number 2, relax. What that means is that you are not, Mr. President, is not to appoint members, say that Abiam, Crosby, justices of the Supreme Court, come. There's a petition for the removal of our enemy. Come and remove her. Kunzo Tiani, Etonam, Wendy, come. There's a petition. Come and sit. No, that decision is a shared responsibility or decision between the president and the Council of State. Number 2.
Wait.
You relax for me.
You have spoken some. I'm coming. You have spoken about the president's involvement in all of this. You say he was mentioned a couple of times, but he is doing this in relation with the Council of State. So it's not like the president alone is taking that. We know the part of the country we are in. We know how things work in the country. The president is appointing 3 people, and then
he's not appointing. You see, I'm taking pains to explain that. The president is not appointing. The president is consulting the Council of State to appoint. It's okay. Do you know how?
Relax.
Are you suggesting?
Yes.
Are you suggesting that the president will sit in his office and appoint and tell Council of State to endorse? Is that what you are telling me?
So where the petition is for the removal of the Chief Justice, the president shall, acting in consultation with the Council of State, appoint. So the president is the one still doing the appointing in consultation with the Council of State. It's not the Council of State who is doing the appointing.
I am saying that decision, there are 5 members of the committee.
Yeah.
Constituting that committee, it's not the sole decision of the president. That is all I have said. I'm saying that the Council of State has a shared responsibility in that. It does that with the president.
Okay.
If your argument is that the Council of State is a rubber stamp institution, that will say that, Mr. President, the Constitution says constitute a committee. Where is your committee? Let us endorse it for
let's
you.
speak with
If you are saying that is what will happen, then I cannot argue with you.
Edem Senanu is an anti-graft campaigner. Mr. Senanu, thank you for making time for us this morning. An interesting development coming from yesterday in the evening. From where you sit, how did you receive this news?
Well, I just received it, and if Ghana were, what they call a series movie, it will never cease to amaze me how there are new episodes that just stun you. You wake up every morning or every week to something really unanticipated. So no, I thought that with the previous petitions which the former president dismissed, that matter had been put to rest.
So knowing that previous petitions were dismissed and a new petition from 3 petitions from 3 people is going this far, people seem to think it was something the president wanted to do already.
I think it's not useful doing all this kind of speculative thinking and discussions. That's not neither here nor there. What's important is what's the substance of the petitions. Do they have merit? If they do have merit, then there are issues we must consider, and therefore the legal processes must be followed. My first thoughts when I heard about it was that, persons in positions of trust will now have to take very seriously whatever mandate and responsibilities they are giving, so that they do not put themselves in a space or position where you can have these various things, attempts to remove you here and there. We probably need to be much more cautious when entrusted with responsibility. So those are my initial thoughts.
We've gone through the process for the removal. We've gone through the conditions that need to be met. Now, how do you explain stated misbehavior, for instance?
Well, I don't know which misbehavior is being described, but typically in an administrative framework, there would be documents, codes of ethics, professional, ethics that describe, or administrative policy documents that outline what steps must be followed in what circumstances. And so if they say misbehavior and it is personal, then you will have to demonstrate that there's been a breach of the professional code of ethics that have been outlined, or there are some administrative processes that were not followed, etc., etc. There has to be a context or a framework within which this can be settled.
Adam, let me bring into the conversation Justice Abdullahi. He's Osman Al Hassan. He's a lawyer. He's joining us for that conversation. And Osman, thank you so much for joining us on the program. I just asked Mr. Senanu about the burden of proof instance in this conversation. Amongst the things to consider is stated misbehavior, and then the third condition. There's a second, and then there's a third condition apart from the stated misbehavior. In fact, the second is incompetence, and then the third ground of inability to perform the functions of his office arising from infirmity of body or mind. How difficult will it be to prove something like this?
How difficult would it be
to prove something like this?
You mean all the 3 conditions?
Exactly.
Well, it depends on the circumstance. it depends on the circumstances. It might be difficult in some circumstances. It might not be difficult in some circumstances, depending on what allegations have been made. You know, the proof of these things must first, before the proof, they must first be alleged. And then the background, the causes, or the conduct of the person which gave rise to the allegation will now determine the availability or the difficulty or otherwise of proving those allegations. So it's not I should say a one-way thing. It can be difficult, it can be easy, depending on the circumstance.
Adam Senano, and this one is to you. So there's also incompetence or on the ground of inability to perform the functions of the office arising from infirmity of body or mind. Again, on the burden of proof in this petition, how should we look at this from?
I'm actually curious about some of these allegations, so to speak, because for somebody to have risen through the ranks to the level of Chief Justice, there would have been the various levels of assessment that would establish the competency or otherwise to move you from level A to B to C. And so I think your question is appropriate to the extent of I don't see this as a very easy task unless there are, for example, specific points of law that it can be shown that your thinking, your decisions were way off. But typically, the decisions, usually it's a panel, it's not an individual. So it's very difficult in my mind to conjecture, let alone to be able to establish. So they must have some specific examples they are keeping up their sleeves, which they're going to use. And if they can demonstrate that there is a pattern, then yes. If the examples are such that, for example, relating to administrative actions taken, which are totally way off the existing administrative policies and processes that are required, and there is a repeated pattern, that, for example, could be a space where one could begin to make an argument. But at the moment, it's probably much more conjecture than fact, at least from my end.
Right.
Yeah.
Adam Senano, please stay on the line with me. Counsel, so we're looking at the appointment, the president appointment in consultation with the Council of State, of course, of these 5 people who, the committee who will work on this petition. How should their approach to work on the petition be like?
The approach of their work?
So I'm asking of the 5-member committee that will be put in place by the president in consultation with the Council of State as they work on the petition. How should they approach their work on the petition?
Well, I think there has been precedents of this kind. I think theirs is to establish the Prima facie case. If there is a Prima facie case for the next step to be taken, we all know that this is something that has been added to the express provisions of our Constitution in the case of a Chief Justice, but it appears to be an accepted norm that, okay, even in the case of a Chief Justice, if she is due or he is due for the process of removal, then a prima facie case has to be established. Yes, so, but my point has always been that, prima facie case requires the assessment of evidence. You see, no matter how you look at it, you can't make an assessment of prima facie case just by looking at allegations. Now, without evidence, if you say you are establishing prima facie case, it will sound a bit novel to the time-tested principles of law that we all know. You know, facts, allegations, and evidence have very little and very thin distinction that must be taken into account in the work of whoever is due or whoever is supposed to establish what we call a prima facie case. You know, so it means that the prima facie case means that some evidence has been proffered to support or to prove the allegations in such a manner and with such a way that if the person against whom the allegations are made has not come to his or her own defense, then it will suffice for the ultimate to happen. That's what we call prima facie case. So it means they have established evidence, and if you don't come and answer those allegations, then you can be removed.
Osman.
So it is not. I think that this is an approach. They have to take an approach where evidence has to be adduced, and if evidence has already been part of the petition, then of course it will have to be the basis for the establishment of prima facie case. If it is not, then of course they have to hold a hearing, give the Chief Justice a hearing against whatever evidence has been proffered against her, in order to now come to the conclusion that there is a prima facie case or otherwise.
Osman, and this will be for you both, Counsel, and then Mr. Senanu. But first, Osman, even in the face of the strict adherence to the legal process or the procedures laid out in conditions like this, is there the possibility of political influence or any other influence in a matter like this?
Is there?
Is there the possibility of any influence, maybe political or otherwise, in a matter like this?
Of course, everything in our country always have the possibility. Possibility is what it is. Plausibility is what we can't say. You know, as for possibility, everything is possible. But whether it is plausible is another thing. So for me, in every activity, every decision, there is in our country, for instance, and at the stage of political development we have reached, you know, we have that possibility that almost every decision might have the possibility of being influenced by some partisan politics. Okay, but whether that is the case in this matter is another debate, because it can be possible but not plausible, and it can be possible and plausible. In actual fact, whether there is or not, that we can't say, but the possibility can be there, and it might also be possible that it is not there. So either way you look at it, because look, I had a cause to say somewhere that the removal of the chairperson, who was placed also in the position or at the status of a court of appeal judge, and the way and manner she was removed, I had a cause to write somewhere and say that, look, this was an action that has set a stage of partisan political vendetta moving forward. You see, there are positions that the Constitution has protected so jealously that it shouldn't have been that easy for any such influence to come in when it comes to their tenure. But hey, the Pandora box for me is open. It's open because the basis on which that woman was removed from office opens up, has lowered the bar, lowered the standard, in my opinion, for others to follow. And if they follow, my point has always been that if you never spoke when the first stone was cast, then you must remain silent. You know, I know people will be talking about whether the standard, whether what is done is heavy enough or is heinous enough to warrant this action or that action, which is talking about standards. Okay, but such people, if I find that you didn't say anything at the time, I will think that I will not take you seriously if you are talking now. But it is a general problem we have, and we must face it. The partisan political vendetta bit that I referred to it's possible for it to also come to play. But by and large, if there are instances, because this is a constitutional provision,
right?
A constitution makes provision for the appointment of an officer and makes provisions for the removal of that officer, no matter how competent you were at the beginning.
Right.
The constitution still contemplates with the provisions for removal that you can deceive us from the beginning, but now show us your real self if you are in the office. And so you can appear competent from the beginning, but actually demonstrate incompetence while in office.
Right.
And so if they actually are there, if an officer demonstrates such incompetence or demonstrates such misbehavior, okay? Remember, the Constitution spoke about misbehavior and incompetence, which means the two are not the same. And each one can stand as a separate item and basis for removal.
I see.
They need not come together. So if it is incompetence, if it is misbehavior, you see, you can be competent and still misbehave.
Right.
And so for me, your initial qualifications, apparent it might be, but if you misconduct yourself in the office, I think the Constitution contemplates that to happen, and it also makes provision for your removal.
I see.
It's as simple as that. This is the Constitution. Yeah.
Adam Senanu, so still on the same subject, talking about strict adherence to the legal procedures and the possibility of a certain kind of influence. If that happens, what does the optics say? What message will it convey to the people who are following the development?
Well, that's a possibility. There definitely is a possibility. Even in terms of the three petitions, it could have a root of some partisan political interest that has triggered the initial petition in the first instance. As to whether that would then obscure how the facts will be dealt with is a separate matter, because once the panel has been constituted and examine whatever evidence, and my colleague has already established how it's important that you cannot arrive at a conclusion on a prima facie case if the evidence has not been provided for allegations and they are substantive for you to draw that conclusion. In my mind, because of the high-profile nature of this position, for all of us, it will be very important that the panel is able to clearly and logically draw the conclusions between the administrative or legal provisions that have been breached, as may be the case, and the verdict, or if it hasn't been, and therefore this is something to be dismissed, I think that whatever the write up is eventually should be one that is targeted at being above board, so that everybody has clarity. I think that the panel that's constitution owes it to this country to do what is right in terms of the constitutional, legal, and other provisions. I think that is really critical. And hopefully, and I very much side with my colleague. I'm comfortable with this constant attack at this government. It's the kind of precedent it sets. Means that, first of all, you are likely to also have a situation where persons of competency who otherwise may be willing to take up such positions in future, but just say that, look, this is just trouble. So we need to be cautious. Whilst the politicians may see this as where we score points or we are determining our future, I think it is short-sighted, because that future of putting somebody who you are comfortable with will probably just last for the tenure of your government. And that cycle does not get us anywhere. So we need to be cautious even as we take these steps. And the panel owes it to us to make sure, if the president goes ahead, that they do something which is above board.
And Adam, this is still to you. Is there any kind of resistance that this process that has started may face going forward? The CJ is the lead of the judiciary. What forms of resistance, if any, can be marshaled against the entire process?
Well, if there are strong counter legal arguments, and I think that at the end of the day, it's the nature of the allegations, the evidence attached to it, that would then open up the space for people who are thinking through counter arguments, etc., and whether there are legal, opportunities for that to happen. I think the Constitution already lays out the process, so there's a sense in which we ought to be sticking to that process. But if there are other opportunities, you find that once the allegations and the evidence supporting it is out there, every possible avenue, if there are to counter this, will come up. I'm quite certain of that. So I don't think that this is just you are just speculating. I'm quite sure that if the allegations and the evidence is out, we will not be also commenting, and if there are other actions, they'll be taking. The lawyers will certainly start advising their clients, and the Chief Justice will definitely take advantage of that as well.
Adam, please stay on for me for a final question. But before that, Counsel, looking forward, what kind of resistance can be mounted against a process like this?
Well, it depends on the allegations. First of all, the resistance can come in the form of legal defense for the Chief Justice, and which may come in the form of either challenging the factual basis of the allegations, or challenging the evidence in support of those allegations. And it may also come in the form of an argument that, granted that those allegations are true, are proven by the evidence, they are not sufficient. They are not sufficient for the removal of an officer of that nature. And that's why I initially talked about standards. The standard for which threshold must be reached for it to be clear, very clear to everyone that this conduct constitutes the kind of misbehavior that the Constitution contemplates, or this conduct constitutes the kind of incompetence that the Constitution contemplates for the removal of such an occupant of such a high office. So there can be these ones. And of course, there can be resistance maybe from the public, you see, and that's why sometimes if you're a public officer, you should conduct yourself in such a way that even if the political head or someone or certain processes of removal is instituted against you, the public can come to your defense. But that will depend on how you serve the public and how you have conducted yourself or how the public perceive you in that office. You see, the power always goes to the people at the end of the day. So if there is a resistance against the constitutional procedure, I believe it is one of the things that the authorities would like to consider, because this government, no doubt, has demonstrated that it's a government who is here to serve the people. But the question is, will the people take the removal of the Chief Justice in good, as a positive one or a negative one? And if they take it as a positive one, it will be telling on what they perceive the Chief Justice to be. And if they take it as negative, it is also telling on what they perceive the Chief Justice to be. But either way, it will have an effect in the form of resistance against the process. Not resistance in the manner or in the way that we might think about it, but it is a subtle but strong force. For instance, if the whole country, I'm just giving an example, if the whole country gets up and pour into the streets and say, we don't want the Chief Justice removed because she is a good Chief Justice, she has served us well, so don't remove her. Whatever it is, we know they are mounting on a constitutional procedure, but the Constitution is adopted by the people. Though sometimes it's difficult to balance complying with constitutional procedure and also listening to the people, it is something I believe can come in the form of the resistance that you are talking about. But in my opinion, I don't think the Chief Justice will get that from the public. So these are the various ways I think it might be resisted. Of course, and you know, you guys are also a very convenient conduit through which such resistance can be mounted. You know, we can have lawyers and other people perhaps doing the media thing. So all form of resistance can be exerted, but at the end of the day, I believe the constitutional process will carry through.
I see.
The question is, yes, whether it ends in the removal or otherwise, it's what we can't tell. But once the petition has been forwarded to the next stage, I believe it will be carried out.
And Counsel, thank you. But we'll talk more, maybe on another subject. Please don't leave the line. My final words to you, Adam Sinanu, on this subject, my final question on this subject before we delve into other matters is that now, if it happens, and I'm saying if it happens that the CJ goes through the process and is removed or is not removed, what implications is it likely to have on the judicial system, on the legal system in Ghana, regardless of the outcome?
I think that even the constant petitions and these efforts, to a certain degree, denigrate the status of the judiciary in the eyes of the public, and it's an unfortunate one. In my mind, I think that we would be better served if some of these things, as my colleague just said, the standards are clear, and before we even think of triggering on initiating them, the due diligence has been done to satisfy the minimum thresholds before we even begin. So that's constant attempt at removing officers of this level, I think doesn't serve our democratic experience very well. I think that certain positions we shouldn't do these things just as a matter of course. Every other month or two, have new petitions. There should be some kind of screening that reduces this to the very, very necessary. So I think that already we will be experiencing some denigration of the importance of the role of the judiciary within the democratic dispensation as a result of such petitions. If it actually went through and the Chief Justice were removed, obviously that would be a new milestone, but it just means that you can anticipate that in future there will be other people attempting this, and that kind of cycle would not serve us well as a country. So we probably would need to rethink based on what exactly the facts are, assuming that we ended up removing the CJ, would need to put in place measures to make sure that this kind of situation does not easily arise. That will be critical.
Sinanu, thank you, but please stay on the line for me as we get into other developments this morning. Back to you, Counsel Abdullahi. So, Al-Hassan, sorry. Let's talk about the latest concerning the lawyers for Edubuahin suing the AG and Iyoko. Now, a High Court is set to hear the bill application that is filed by the lawyers for the former Director General of the National Signals Bureau and his wife. The suit is naming the Attorney General and the Economic and Organized Crime Office as respondents. Now, we know that the couple were arrested and detained under what their legal team is describing as unreasonable and burdensome bail conditions that undermine their right to liberty. And they're arguing that the authorities are deliberately frustrating their release with excessive bail terms. From where you sit as a lawyer, how does this, application filed by the lawyers against what is going on by the AG and the Iyoko, how does it work? How do we reconcile the two?
Reconcile what and what?
So you know that the lawyers for Edubuahin have filed an application that the bail conditions set by the AG and the Iyoko are unreasonable and burdensome. So we know that the AG also granted them bail, but the conditions have not been met. So from where you sit as a lawyer, how do we reconcile the two? How do we marry the two?
Well, I need to get this clearly. Was the initial bail granted by the AG as an inquiry bail, or it was granted by a court? I need to get that clearly.
So what we understand is that the bail was granted by the AG.
Okay.
But they could not meet it because they say that it is unreasonable and it is burdensome. The AG set bail for the man, and I'm talking about Edubuahin, at 120,000 cedis, and for the wife at 80,000 cedis.
Yeah, so because this matter is pending in court, we have to be careful not to be prejudicial to the outcome that we are yet to know. But to answer your question, I think, when bail conditions are being given, they take into consideration a lot of things. They take into consideration the nature and gravity of the offense that is being investigated for prosecution. And for me, I think it is a step in the right direction for the bail to be contemplated in the first place. So it is good that we are not talking about an outright denial of bail. I'm happy that we are not talking about an outright denial of bail. Now, if they were to keep him without bail beyond 48 hours, definitely my posturing will be different. But at least I am happy that we are now talking about conditions of bail. Now, but the conditions of bail, as I said, they take into consideration a lot of things. Now, the charges or the offenses that are in contemplation here are offenses that involve quantums of money. And what is bail? Now, bail is a respite or a reprieve given to an accused person or a suspect, to go home and return as and when the investigative body or the court requires to assist the investigation, so that in the meantime you are at liberty to be at yourself. But you see, the bail always take into consideration the possibility or your ability or your honesty to return at the times that you are required. And secondly, they look at what will be lost if in the course or if in your bail you become a fugitive to justice. Because there is always a contemplation within the law that any person accused or a suspect granted bail can abscond the criminal process. And so if they look at what the quantum of money involved in the offense you are charged, they give you the condition in such a way that whoever is standing surety for you will pay that amount if you never return for the investigation or for trial.
Right.
Yes. So that is what I think we should be looking at. So that and that's why I believe it is to be justified. Now, justified, I believe, I don't know the nature and the standard of evidence that's available to the Attorney General and the police or the law enforcement bodies. But for them to give, one can infer that perhaps the evidence is so strong that the offenses and the amounts involved can be proven with the evidence or findings that are available to them. And so, but they still think that you should get bail. But if you get bail, then of course, they make provision for a situation where the accused person absconds. And so that's what bail is. So that's why they always want sureties. A surety comes to undertake that in case of the undesirable situation we contemplate, this is what you will do. This is the amount you will pay. So I think that's what we should be looking at. And if we look at that, we will now be able to assess whether those conditions are justifiable. Because if they are justifiable, of course, they won't be considered as a denial or an implied denial of bail.
I see.
But if you are not, yes.
Now, counsel, the conditions require Adubuahin to post a bail bond of 120 million cedis. I said 120,000 cedis at first. 120 million cedis with justification. And the wife must meet an 80 million cedi bail condition also with justification. Now, as an independent practitioner watching this and following the development, do you think that these conditions are unreasonable and burdensome?
No, that's why I said it depends on the circumstances. How much money is involved in the offenses that they are alleged to have engaged in? How much? So it depends on how much. If the amount is up to that amount or anywhere close, then of course I think it is justifiable for the amount, and it can't be unreasonable or burdensome, because if you are charged with the laws or the, I don't want to use the word, if you are charged with, or if an appropriation, misappropriation, or stealing is alleged against you of an amount, let's say, of 10 million.
Counsel, the amount that we're looking at is in excess of $5 million, and that can be translated into 27 houses bought in a day at an estate. Now, it is over $5 million because we needed to buy a software worth $7 million, but only about 1 point something was paid. So the AG is saying that $5 million is with, or Mr. Dubois dealt with that $5 million as a private individual. So based on that, the 120 million and the 880,000 million cedis, is it burdensome and is it excessive? Mind you, there's a $1 million worth of property at Mayfair Estate. There's a $500,000 deposit to acquire 5 houses at Mayfair Estate. There's a $200,000 house purchased at Mayfair Estate. There's a $150,000 house purchased at Mayfair Estate. $97,000 house purchased at Mayfair Estate, and $270,000 house purchased at Mayfair Estate as well.
Yeah, so you can see that the amount is approaching perhaps $6 million.
Exactly.
So $6 million, if you calculate $6 million in cedis, would it be less than less than 200 million Ghana cedis? That's what we are looking at. If it is not less than 200 million Ghana cedis, then of course one cannot say that the bail condition is burdensome or unreasonable. But if it is far less than that, then maybe they can be talking. But here, it is not. If they say it's burdensome and unreasonable, then of course they must be willing to tell us what is reasonable and not burdensome, because the conditions of bail are not arrived at arbitrarily. As I said earlier, they are not arrived at arbitrarily. So if they have a better way of assessing the conditions or giving better conditions, then they must put it out and defend it. And I believe that's what is going to happen in the courts above. So to say they are burdensome and unreasonable is a question of both law and fact that need us to take into consideration the basis for those conditions.
Counsel,
and that's what I just said. Yes.
Right. Now, they're also saying that they're arguing that the terms are excessive and amount to a deliberate attempt to keep them in detention beyond their constitutional 48-hour limit. How does that work in a case like this?
That sounds speculative. You see, so this is someone's opinion. If they say it is excessive and it is intended to keep them in, for me, it sounds speculative. It is an opinion, but that opinion must be supported by the evidence, the facts, and the law. Because if you advance a principle of law and support that principle with the facts, both arriving at the conclusion that indeed the current conditions of the bail, giving the amounts or the quantums of money involved in the offenses, is excessive, is burdensome, is unreasonable, as I said earlier, then of course there will be change. But that will require you to also give us what is reasonable and what is lawful and what is not burdensome under the circumstances, because you are looking at what the state will lose if their allegations is indeed proving or can be proven at a time when they are not available to face trial.
Right.
And you are also looking at the liberty of the individual. So it is a balancing act.
Okay.
They will have to now provide evidence and then the principles of law to demonstrate that those conditions are excessive. But as in my opinion, as I said earlier, given the quantums of money involved and perhaps given the nature and strength of evidence available to the prosecution, it might as well be justifiable. And so they just justify it and let the man go. Because, as I said, we are not talking about outright denial of bail. We are talking about bail with conditions. And I'm not sure that they want to say that it is impossible to get someone within the jurisdiction to have this amount of money or to be worthy of this amount of money. I'm not sure that's what they are saying.
Right. Counsel, briefly from you two. So in the affidavit as well, here are excerpts. The upshot is that the respondents have committed a constitutional infraction by denying the applicants, and I'm talking about Mr. and Mrs. Adubuahin, their right to counsel, and shall continue to do so until the court intervenes in this travesty of justice. So my question is, bearing in mind all the reasons why they are asking this high court to hear the bail application, what does it look like, briefly?
What does what look like?
The reasons they have given why they need the bill. And the last reason we're talking about is that they are accusing the respondents of committing a constitutional infraction by denying the applicants. And I'm talking about Mr. and Mrs. Adubuahin. Yes.
Yes, so this is an allegation. For me, I have no access to the information that warrants this allegation. And I'm not sure, I don't know if that is true, if they have been denied access to counsel or not. It's a matter of fact that must be established. But if it is true that they have been denied access to counsel, of course, the court will address it. But I am not sure that what they are saying is correct. Because, most of the time, there is a saying in my language that you don't tie one tuber of yam, all right? So, which means that you don't take a decision or you don't decide based on one-sided story. So, I haven't heard anything from the law enforcers on this allegation.
Right.
They have been denied access to counsel. But what I will say is that generally, I have had experience of such. It is deplorable, it is undesirable that you deny an accused person an access to counsel. That, in general, all of us agree that it is unconstitutional, it is unlawful. But the question of whether it is factual, it is the fact, is what perhaps they will be proving in court.
Right.
And if they prove it, the court will deal with it appropriately.
Osman, thank you so much for your time with us this morning. Osman Al-Hassan is a private legal practitioner speaking with us. We also have on the lines Ed Dempson, an anti-graft campaigner. He has also been following the development concerning Mr. and Mrs. Adubuahin and the latest from their outfit asking the High Court, a High Court is said to hear a bail application they filed, on their behalf by the lawyers of the National Signals Bureau, the former Director General of the NSB, and his wife. Mr. Sananu, with how the case is developing and the new angles emanating, briefly from you, what do you make of all of this?
Well, first of all, 27 houses in 4 years. That's just out of this world. And the facts by themselves raise major concerns for me as to systems failure. Because in my mind, this should ordinarily not have been possible. How is it possible that a facility that was supposed to be for the state, you can have private individuals siphoning out of that and having monies that they then use for their own personal benefit. Somewhere on that value chain, there ought to have been the red flags. And so there is a need to look at the processes Usually things regarding national security, there is no full disclosure. But I think in this instance, it raises questions, and to the extent that this has happened, we ought to look much more clinically at the processes that were involved in terms of trying to make payments and how it was possible for an individual to access these funds, etc. So major concerns beyond retrieving money, beyond sanctioning individuals. There has to be a review of this system to make sure that this cannot happen. For all you know, it has happened in other sectors or quarters already, and that's a very frightening thought.
Adam, I'm sure this also opens the question about tracking illegal funds. How are we doing in Ghana, and how can we improve it? Very briefly, sir.
Well, we've kind of reviewed our legal framework to make sure that we've aligned with the frameworks on illicit financing. I think what we don't have is sufficient laws that allow the various investigative bodies to easily pick you up. I'm happy the FIC has been able to say, looking at the amounts involved, they want some individuals. I think there's another case. I think it's like the Quay case to justify, the resources, etc. There is need to improve and enhance the legal framework to make it easier for the various law enforcement agencies to pick up people, do lifestyle audits, and on the basis of that, if you cannot determine clearly a legitimate source for these funds, that they are confiscated to the state. At the moment, I think it's EU code that has a clause that covers some of this. But I think that we can improve that our frameworks to make sure that this is much more easily dealt with.
Adam Sinano, I appreciate you so much. Thank you so much for your time with us on the program. Adam Sinano is an anti-graft campaigner there, but also on the phone lines was Osman Al Hassan. He is a private legal practitioner.